Immense backlogs created by pandemic has dragged U.S. immigration processes to a crawl. As part of fiscal year 2023, we can accept higher numbers of green cards to be processed. The employment-based (EB) annual limit for fiscal year (FY) 2023 will be higher than was typical before the pandemic, though lower than in FY 2021 and FY 2022. We are dedicated to ensuring we use as many available employment-based visas as possible in FY 2023, which ends on September 30, 2023. In this video, we will discuss about the U.S. immigration fiscal year 2023, visa availability, backlog reduction, green card processing and more. If you are interested in any of these topics, please stick around till the end of this video for your immigration updates.
Visit our Swat&Vee channel with your questions to see how best we can help you out your process. Please don't forget to subscribe if you're new to the channel.
Now, let's get into the video. Question number 1. Can you estimate how many family-sponsored or employment-based immigrant visas Uscis and DOS will use during FY 2023? DOS currently estimates that the FY 2023 employment-based annual limit will be approximately 200,000, due to unused family-based visa numbers from FY 2022 being added to the employment-based limit for FY 2023. Uscis is committed, with its partners at DOS, to using all the available employment-based visas in FY 2023. Question number 2. Why has DOS retrogressed certain final action dates or applied new final action dates in the visa bulletin for October 2022? The first visa bulletin of the fiscal year each October, DOS makes reasonable estimates of the available employment-based immigrant visas in each category. It then, in collaboration with Uscis, reviews the pending inventory of adjustment of status and immigrant visa applications, makes reasonable estimates of new applications, estimates how many of the pending and newly filed applications are likely to result in visa use during the fiscal year, and compares those values to the available visas. Question number 5. Does retrogression affect my priority date or place in line for an immigrant visa? If a non-citizen is seeking a visa in a preference category that required a labor certification from the Department of Labor, DOL, their priority date generally is the date DOL accepts the labor certification application for processing. For all other employment-based preference categories, the priority date generally is the date Uscis accepts the underlying petition for processing. Retrogression does not affect your priority date or your place in line for an immigrant visa. You may still receive a visa when one becomes available to you based on that priority date. Retrogression only means that due to the statutory limits, visas are not available to all non-citizens who want them, even if they have already filed an application for adjustment of status. Question number 6. My category retrogressed or a final action date was applied. What is my path forward to a green card? When a visa becomes available to you in the future based on the final action date for your country and category as compared to your priority date, Uscis will be able to adjudicate your adjustment of status application. For as long as your I-485 application for adjustment of status is pending, you are eligible to seek certain benefits. Question number 7. When is a derivative child's applicant age locked under the Child Status Protection Act, and how is that age calculated? In the employment-based preference categories, a child's age under the Child Status Protection Act, Cspa, is the child's biological age at the time of visa availability less the amount of time that the underlying petition was pending, but only if the child sought to acquire status as a lawful permanent resident within 1 year of the date a visa is available. Question number 8. If I am applying for adjustment of status, should I submit Form I-693 with my Form I-485? Uscis encourages adjustment of status applicants to submit Form I-693, report of medical examination and vaccination record, with their Form I-485, application to register permanent residence or adjust status. Doing so will help limit the need for Uscis to send requests for evidence, reduce processing times, and aid Uscis as it works with DOS to use all available visas. Question number 9. If I did not file a Form I-693 with my pending Form I-485, should I send one in now or wait for Uscis to request it, and why? Non-citizens with pending adjustment of status applications should not send an unsolicited Form I-693 to us. Given the rapid movement of files between directorates and offices as we strive to optimize resources across the agency, it would be difficult to match an unsolicited Form I-693 with the related adjustment of status applications in a timely and efficient manner. This could delay the adjudication of adjustment of status applications while Forms I-693 are matched up to adjustment applications. The 60-day rule, which has been temporarily waived, does not apply to Forms I-693 signed by the civil surgeon after you have filed Form I-485. Question number 10. My immigrant visa petition has been approved and I have a pending adjustment of status application. What happens next? In FY 2023, USCIS intends to transfer adjustment of status applications in the first three employment-based preference categories from the Texas Service Center, TSC, and Nebraska Service Center, NSC, to the National Benefits Center, NBC, after the approval of the petition. The Field Operations Directorate will adjudicate the adjustment of status applications. Question number 11. Why does the data on the USCIS website show such lengthy processing times for employment-based Form I-485s at the Texas Service Center and the Nebraska Service Center? We understand that it can be disconcerting when the processing times on our website, especially at the Texas Service Center and Nebraska Service Center, are significantly longer than the agency-wide processing times. However, this is the expected result whenever Uscis transitions a workload from one operational component to another. The few applications that remain at the TSC and NSC are those that have already been pending for some time where the centers are completing the adjudication. As the service centers adjudicate the few remaining old applications, the reported processing times for those centers will increase. Question number 12. How does the transfer of underlying basis request process work? We have created a centralized location for the receipt of transfer of underlying basis requests between the employment-based preference categories that are accompanied by a Form I-485 Supplement J. You may submit your written request and completed Supplement J to U.S. Department of Homeland Security, Montclair, California location. Question number 13. How does a transfer of underlying basis request affect the calculation of a child's age under the Child Status Protection Act, CSPA? An applicant has multiple approved petitions. The applicant's CSPA age is calculated using the petition underlying the adjustment of status application. When we approve a request to transfer the underlying basis of the pending adjustment of status application, we calculate the CSPA age using the approved petition that forms the new basis of the adjustment application. If we transfer an applicant's underlying basis, then we calculate an eligible applicant's CSPA age using the applicant's age at the time the immigrant visa becomes available in the new category minus the time the immigrant petition that forms the new basis of the adjustment of status application was pending. Question number 14. If the immigrant visa petition underlying my pending adjustment of status application has not been adjudicated, will this prevent me from transferring the basis to a different petition? If you have a pending petition, that does not prevent us from granting a request to transfer the underlying basis of your pending Form I-485 to a different Form I-140. Question number 15. Why must applicants request to transfer the underlying basis of their pending Form I-485? Why does USCIS not review its records and make the decision for the applicants? The decision to grant a transfer request is made in the discretion of USCIS. If we grant the transfer request, we will adjudicate the Form I-485 application based on the petition to which the Form I-485 was transferred. If we do not grant the transfer request, we will adjudicate the Form I-485 application based on the petition associated with the Form I-485 application prior to the transfer request. Question number 16. Why does USCIS not allow non-citizens to apply for adjustment of status based on the dates for filing chart every month of the year? When we determine that there are immigrant visas available for the filing of additional adjustment of status applications, non-citizens must use the dates for filing chart to determine when to file an adjustment of status application with USCIS. Otherwise, use the final action dates chart to determine when to file an adjustment of status application with us. We make this determination monthly based on how many visa numbers remain available for the year, USCIS and DOS visa available inventory, and operational considerations. Question number 17. When does the special exception to the per-country levels for the employment-based categories apply? If the total number of visas available in one of the employment-based categories for a calendar quarter exceeds the number of qualified immigrants who may otherwise be issued such visas, the visas made available in that category will be issued without regard to the per-country numerical limitation. This can happen as early as the first day of a fiscal year, depending on the relevant data. Question number 18. When USCIS adjudicates a principal applicant's adjustment of status application, does USCIS also adjudicate the adjustment of status applications of the dependent family members? What if dependent family members are not approved before priority dates move back? Uscis makes every effort to adjudicate the principal and derivative family members at the same time, but this is not always possible. If we deem approvable a Form I-485 of a derivative family member and a visa number is not available, we will request the visa number from DOS, but the case will remain pending until a visa number is available, DOS allocates it, and we complete the adjudication.
I hope you guys found this video extremely helpful. If you know anybody that could benefit from this information, definitely make sure to share this video with them. We are all about empowering you with knowledge. So the more people that can benefit from this video, the more people we want watching this video. If you like this video, please make sure to hit that thumbs icon. Thanks for watching, and don't forget to subscribe and hit on the notification bell for more immigration updates. Bye!